Hello, everyone. Welcome back to Radio Entrepreneurs, the show that keeps featuring how people in this economy are continuously adapting and dealing with success in this economy and creating success. And every week, I think people know over many years, we like to check in with Mark Furman, director and shareholder at the law firm of Tarlow, Breed, Hart, and Rodgers for our segment, Entrepreneurship and the Law. Welcome back, Mark.
Hi, Jeffrey. Great to see you today.
You too, Mark. Everything's changing, but everything's still the same.
That's true, Jeffrey. Both in, I think, what you do and what I do.
Right.
So we've recently talked about how corporate owners are not, can be found to be personally liable for certain legal matters, despite the fact that they're operating in a corporate structure, either a corporation or a limited liability company. It doesn't shield you necessarily from personal liability. So, I just want to continue to emphasize that business owners do not have unlimited discretion. We have this highly complex legal system, regulatory system that gives rights to people other than the business owners, whether we're talking about employees, whether we're talking about vendors to the company, whether we're talking about customers of the company. There are all sorts of laws that create risk. And so one of the things I encourage business owners is to understand the risks and to try to protect themselves against them. And I'll just give one simple example, and then hopefully we can have a little discussion about it. There are all sorts of wage laws that create personal liability. They're quite complicated and easy to violate. So don't assume as a business owner that you can defer payment. Don't assume that if you terminate someone that you can necessarily pay them during the next pay period. For example, in Massachusetts, they have to be fully paid on the day they leave the company. So, I mean, that's just a tiny little example of all the ways people can run afoul of their legal obligations. And of course, firing a minority owner creates a whole different set of risks because of the extensive law that exists on freezing out co-owners. So you need a little bit of being humble and understanding what the limitations are and your discretion as you operate a business. Just certainly you can't discriminate against people on the basis of a whole variety of things, sex, race, and others. You just have to understand there are limitations on your discretion. And some business owners struggle with that because they're the owners, they're in control. So I'm curious what your experiences are, Jeff, in that regard.
Well, there are obligations, and I'm going to just be a little bit more controversial, and I'll generalize. Where I see people who don't understand their obligations as owners, usually is in second and third generation. It's a lot more common that they take the position for granted, especially if they've worked for the business their whole life and haven't worked outside in a corporation. And it's very hard to explain to them something that they've never experienced or learned. That lack of experience, that lack of perspective, that sense of entitlement that sometimes comes with second and third generation is a dangerous dangerous thing. And I see it all the time. I do. And it's very hard to convince people of something they had never heard before or seen.
Yes. So, I think it comes back to business owners making sure they get independent advice from knowledgeable advisors and being willing to learn about the experiences that those advisors have. I always say you need a financial advisor, a consultant like what Mage provides, and legal, financial, insurance. They're all part of a team because there's a lot of collective wisdom and experiences with all sorts of businesses from people who've provided advice to businesses for years and years and years, in some cases, decades. And I like to say you'll learn a thing or two over a 30, 40-year period just by seeing everything that one sees in their professional practice. And so, one of the things I would like to see every business do is to, at some point before a crisis, focus on things you can do to protect your downside as a business owner, protect you and your family from a risk of catastrophic loss. And you can do that in a variety of ways using your advisors to make sure your agreements are in decent shape, that you're following the employment laws, that you understand the limitations on your discretion, that you understand the scope of your insurance coverages, and particularly what isn't covered. It's like, I have insurance means nothing. The question is, what insurance do I have? What protections do I have? And what are the gaps that, as a business owner, I am self-insured for? And I've had numerous cases over the years where a key element for a company is the ability to have insurance coverage that provides a defense to a massive lawsuit that creates an enormous risk for the company. And so you should understand what you're on the hook for out of pocket versus what you have a likelihood of insurance being able to deal with the cost of defense, and in the event you lose, what's covered, what's not covered. So our legal system is very complicated in what is required. It's made more complicated by the existence of emails and texts, and business disputes that I handle now involve thousands of pages of documents, sometimes tens of thousands of pages of documents, sometimes hundreds of thousands of pages of documents, because there's so much electronic communication that goes on in the world today, unlike when I started practicing. And in Massachusetts, in state court, we treat cases that have $500 million or $50,000 in dispute the same in terms of what the rules are. And so I think that's just one thing that's really important. And it's hard for business owners, I appreciate. And because I admire them so much because they have to make so many decisions. The buck stops with them, and they have to make those decisions every day. There's not like a chain of command like you'd have in a gigantic organization that every decision above X amount of dollars has to go through layers of review. It's the business owner.
Business owners are used to making decisions, They're used to being in control. And that's part of the reason they wanted to be entrepreneurs. But they don't always understand, as you've made clear, one, how to protect themselves if they make a bad decision, insurance, and two, where they do have control and where they don't have control. And those are two very important starting points in any business. You got to know what you can do and what you can't do. Because once you do something that you shouldn't have done, there's a lot of history. And it's hard to disprove otherwise, as you say. There's a lot of documentation in this world. I usually try to tell owners, I try to coach them on when to write a note, when not to write a note, when to make a phone call, when to meet in person. And, just that subtlety of different ways of communicating can make a big difference in this world.
Yeah. Another way to look at writings is assume that everything you write, whether it's on a text or an email, is going to be on the front page of the Wall Street Journal or the New York Times or on TV or read by an adverse party or the lawyer for an adverse party. Just assume that there is no privacy about communications, even though they're electronic. Still, people have, I find, a view that if they write a text, that it's private. Nothing is private in litigation other than the content of communications between you and your lawyer. There's a attorney-client privilege for that. But every communication between you and your lawyer that you copy someone, a financial advisor, a business consultant, an insurance person, an accountant with rare exceptions, is not going to be privileged. And people are unusually frank when they write texts, sometimes and frequently emails. And, you talk about smoking gun communications. In cases, they're always found in the texts or the emails because people think they're private, unlike a letter, which they don't have that view as being private. So they say things that their lawyer would prefer they not have said.
And everything you say to your consultant is not confidential for legal use.
Correct.
And I try to remind that to my clients many times when I say, why don't you just give me a phone call? And I think, in the future, maybe we'll be talking about how AI is going to influence these notes, the credibility of notes, the authenticity, who wrote it, how it got sent. I think that's going to change things too, and just make it a lot more of a debate for attorneys like you.
Well, that's the whole AI thing is really interesting. But
I know people who don't write anything anymore without AI. I'm still writing all my own stuff. I'm an old-fashioned person, probably like you. You're an old-fashioned guy. I know that. You still have that little black book inside your sports jacket, probably.
Well, I don't have an abacus anymore, Jeff. So I've made progress, don't you think?
Yes, but that, you are famous for that Furman little black book inside that left front pocket of your jacket. Mark, if somebody's looking for you on how to deal with today's world at Tarlow, Breed, Hart, and Rodgers, how do they find you?
I can best be reached by email at mfurman, Furman, at TBHR-law.com.
Great, Mark. And remind our listeners, Mark is posted on all the social and websites for Radio Entrepreneurs, and you can see him again next week, again on Radio Entrepreneurs.